Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing who is entitled to receive the regular employment insurance benefits when they've lost their job in Canada. And the baseline that we're going to start off with is we're going to look at what the Canadian government says about these positions. So you really want to start off with the Canadian government's position and then work yourself through those processes and understand where they are and whether or not you need legal representation in dealing with those situations and how best to position yourself moving forward. So the overall premise of employment insurance benefits and the receipt of those is that you have to have lost your employment through no fault of your own. But we have to understand what that really means. And we have to look initially to what the government says, because we want to get deviating from what the government is, at least in our understanding. We need to understand what the government agents are going to take the position of, and then you have to work off of that. So what the government first looks at is they consider that you are responsible for the loss of your employment. You may not be entitled to receive employment insurance benefits. So some of the examples that the government has put forth include you left your employment voluntarily and without just cause, meaning you did not cause all the reasonable alternatives available to you to keep your job. Another example would be you were dismissed for misconduct, and it is determined that you voluntarily or deliberately committed this inappropriate action, violation, or professional misconduct. And a further example is you are unemployed as a result of a labor dispute in which you participated, whether it's a strike, a lockout, or other type of dispute. However, the government may consider that you are not responsible for the loss of your employment if your employer ended your employment, but it was not as a result of misconduct on your part, or alternatively, you left your employment for reasons that can be considered just cause for leaving the employment. For example, harassment, discrimination, dangerous working conditions. So, how many hours of insurable employment do I need to qualify for regular benefits under Canada's employment insurance program? And here it depends on your situation. However, in all cases, the hours of insurable employment that are used to calculate your benefit period must have been accumulated during your qualifying period. So we have to understand what your qualifying period is. And that is the shorter of the 52-week period immediately before the start date of your claim, or the period from the start of a previous benefit period to the start of your new benefit period if you applied for benefits earlier and your application was approved in the last 52 weeks. The exception being, in some cases, the qualifying period may be extended to a maximum of 104 weeks if you were not employed in insurable employment or if you were not receiving employment insurance benefits. You will, however, need to have accumulated between 420 and 700 hours of insurable employment during the qualifying period to be entitled to receive employment insurance regular benefits. And the number of hours of insurable employment required is determined when you apply for the benefits depending on the following two aspects: your place of residence and the unemployment rate of your region. Naturally, if you make a false statement or misrepresentation when filing a previous employment insurance claim and were issued a violation, you may be required to accumulate a greater number of hours of insurable employment to qualify for benefits in the future. Now, what does it mean to be ready, willing, and capable of working each day? To receive employment insurance benefits, you need to show that you're ready, willing, and capable of working each day. Being ready to work means that your conduct shows your desire to work, but you have been unable to find a job. Being willing to work means you are actively seeking and willing to accept all types of work that your abilities, skills, training, or experience enable you to do. The wages you are expected to accept may vary depending on your past usage of the employment insurance program and the length of your unemployment. Being capable of work means that you are, first of all, able to work. Ability to work is characterized by the physical and mental strength required to perform the duties of an employment under the same conditions as workers who usually do that type of work. If you are employed in insurable employment, your employer will deduct the applicable employment insurance premiums from your wages or salary regardless of your age. These premiums go into the employment insurance account. There is no minimum or maximum age for paying employment insurance premiums. Now, what happens if you are dismissed for misconduct? The government's position is that, in general, misconduct means any inappropriate action, violation, or professional misconduct committed voluntarily or deliberately by a person who is employed by an employer. Misconduct exists when the employee's behavior goes against the obligations set out in the employment contract and when the employee should normally know that the actions, omissions, or professional misconduct in question could lead to dismissal. If you were dismissed as a result of misconduct, you are not entitled to receive employment insurance regular benefits. After being dismissed, you will need to return to work for the minimum number of hours of insurable employment required to receive employment insurance regular benefits. However, you may still receive maternity, paternal, sickness, compassionate, or family caregiver benefits as long as you qualify for them. Now, what happens if you leave your employment voluntarily? The government's position is that if you took the initiative to end the employment, you are considered to have left your employment voluntarily. What's more, if you did not consider all the reasonable alternatives available to you to keep your job, the government might well consider that you did not have just cause for leaving your employment voluntarily. To receive employment insurance regular benefits, you need to show that leaving your employment voluntarily was the only reasonable alternative in your case given the circumstances. If you leave your employment voluntarily and without just cause, you are not entitled to receive employment insurance regular benefits. After leaving your employment, you will need to return to work for the minimum number of hours of insurable employment required to receive regular benefits. However, you may still receive maternity, paternal, sickness, compassionate care, or family caregiver benefits as long as you qualify for them. Now, what happens if you leave your employment voluntarily, but you believe you have valid reasons for doing so? The government's position is that you may have excellent reasons for leaving your employment voluntarily, but this does not mean that you have just cause for leaving your employment. Before deciding to leave your employment, you should always analyze the problem and use the measures or reasonable alternatives available to you to fix the situation. If you leave your employment without considering all the measures or reasonable alternatives available to you, you will need to explain why you did not consider these measures or reasonable alternatives. Depending on the circumstances, the reasons listed hereafter may be just cause for leaving your employment voluntarily. You are a victim of sexual or other harassment, or you are a victim of discrimination because you belong to an association, organization, or union of workers. You need to accompany your spouse or dependent child to another residence. You are a victim of discrimination. Your working conditions are dangerous to your health and safety. You need to care for a child or a member of your immediate family. You have reasonable assurance of another employment in the immediate future. Your wages or salary have been significantly changed, or your employment conditions have changed to the extent that they have significantly impacted your wages or salary. You are asked to work an unreasonable amount of overtime, or your employer refuses to pay you for the overtime work. Your duties have changed significantly. You experience antagonism with a supervisor, and you are not primarily responsible for the antagonism. Your employer has certain practices that are contrary to law, or you are unduly pressured by your employer or your coworkers to leave your employment. If your employer is permanently reducing its workforce and offers you the option of leaving your job to protect the job of a coworker, we consider that you have just cause for leaving your employment voluntarily. However, the government's position is the company you work for must show that the downsizing is permanent and that your resignation allowed the company to protect the job of another employer. If your employer gives you the option of leaving your job within the context of a workforce reduction, it is beneficial to first consult with Service Canada before making a decision. You should not assume that you will automatically be entitled to receive benefits. Also, from the government's perspective, other reasonable circumstances may be considered to be just cause for leaving an employment voluntarily. However, while you may be considered to have just cause for leaving your employment in certain situations, there may be doubts as to your availability for work. For example, if this person who leaves an employment to look after a child or a member of one's person's family, if you are not sure of whether you can establish just cause for leaving your employment voluntarily and your availability for work, either contact Service Canada or contact a lawyer. What happens if you are affected by a labor dispute? From the government's perspective, when a strike, lockout, or other type of labor dispute makes you lose your employment or stops you from working, you are usually not entitled to receive employment insurance benefits. The following conditions apply regardless of whether or not you are unionized or whether you are employed in a full-time or part-time employment. If you directly participate in a labor dispute, you are not entitled to receive employment insurance benefits until the strike or the lockout is over, or you find another regular employment for which you pay employment insurance premiums, and you work for the minimum number of hours of insurable employment required to receive employment insurance regular benefits. However, you may be entitled to receive benefits if you are not participating in the labor dispute. You are not directly financing the dispute. You are not directly affected by the dispute, that is, the conflict at issue will not change your pay or your working conditions, or you had already made arrangements to have a leave of absence approved before the work stops started. For example, you applied for sick leave, maternity leave, parental leave, compassionate care or family caregiver leave, or leave to take authorized training. In these cases, you may be entitled to receive benefits as long as you qualify for them. Now, these are the government's position with respect to whether or not you might be entitled to employment insurance regular benefits. Naturally, the government wants to limit this stuff and can take a very textbook approach to these items. There are many circumstances that can modify this situation, and oftentimes there is even case law that predicates somewhat altering these positions. But what happens is if you are in the gray area, oftentimes it's advisable to speak with your own lawyer, discuss the circumstances, especially in advance where you can, of either taking action with respect to stepping away from your job or approaching Service Canada or a government representative so that your story is straight and correct and you're able to present it in a manner that is most advantageous to yourself. Oftentimes, even the paperwork that comes out from your former employer can be dealt with and properly amended to reflect a situation that allows you to claim your employment insurance regular benefits. Because if you don't take control of the situation, if you don't get the right professionals oftentimes involved in your situation, you could find yourself either having a difficult time of getting them or being misconstrued or misunderstood by the government representative who is following procedure, following a text, following a manual, and determining stuff impersonally with respect to yourself. You want to have everything lined up on your end so that you get what you are properly entitled to, especially where you have been paying into the government's employment insurance program, such that you should be able to draw from it where the circumstances are such that you haven't done anything seriously wrong or inappropriate. Thank you.